Hi, my name is Dwayne Farnsworth. I'm glad that you've joined me for this seminar presentation. I need to explain from the outset that we've recently held a seminar right here in this room with live active seminar participants, and we recorded it, but we found that it was a little bit distracting to see the backs of people's heads. And some of the questions weren't completely relevant to what others would need to know. So what we decided to do is simply to record the seminar content or the discussions that we had. And as you watch the video, if you have any questions unique and personal to your case, if you'll just write them down as you go through the video, give our office a call. I'd be delighted to talk to you about your personal financial situation to see what we can do to help you solve whatever it is that you're concerned about. So what are we doing here today? What are we trying to achieve? We want to look at the options that are available to you if you're having financial difficulty. We're going to talk about the debt collection process. Remember, it's never too late to try to negotiate or work out or settle your debts. You don't always need to look at a bankruptcy or some sort of a debt relief alternative other than just good old-fashioned rolling up your sleeves, figuring out where you are financially, and then contacting your creditors to work with them. You want to be a little bit careful with that because you don't want to let your situation or your entire plan or program be put before the creditor before you understand what all your options are. That's why we're here today. Now, when I go to a seminar, I want to know, why is that person at the front of the room even qualified to teach me? So let me introduce myself. I've been practicing as a consumer bankruptcy attorney, doing negotiations, doing non-bankruptcy work, but advertising as a consumer bankruptcy attorney for 25 years. I've been in Arizona. The most prestigious consumer bankruptcy organization is called Arizona Consumer Bankruptcy Council, or ACBC, and they have chosen me and selected me as the Attorney of the Year. I've also been selected by the Attorney at Law magazine as their Attorney of the Year and specifically an Attorney of the Month. I've been peer selected for Arizona's finest lawyers. You can't buy your way onto that. You can't submit your own name. Your peers select you, recommend you, and then you're inducted into the Arizona Finest Lawyers program. I've also been the host of the Debt Relief Show on KFNX 1100. That teaches you a lot when you have to put on and present a 1-hour presentation week after week. And finally, I'm an adjunct professor of law at the Phoenix Law School, Arizona Summit Law. Well, let's talk about let's talk about debt relief alternatives. The debt relief alternatives, I see them on a continuum of different options that you have. First of all, on this end of the continuum, do nothing at all. On the other end of the continuum, file a Chapter 7 liquidation bankruptcy. So let's look at this continuum or selection of potential choices. Doing nothing at all is a perfectly rational, logical approach that some people can use. I've had clients over the years that don't have an income that can be taken. For example, Social Security income cannot be taken by your creditors. They don't have any assets left after they've dealt with whatever they can with their financial situation or their medical situation. So they're judgment proof because there's nothing that can be taken from them. You have to be careful here because you might be judgment proof now, but you could receive a windfall, an inheritance, or a personal injury claim, or some sort of a winning or a settlement. And then all of a sudden, all of this debt collection activity that's kind of been harnessed back just explodes on you when some resources become available. So before you completely deem yourself judgment proof and meaning you don't have to do anything, be sure and be careful to speak with a professional who can advise you relative to options and alternatives that come up. Now, the second and next step is a debt management plan. Credit counseling agencies over the last 50 years have helped people look into their budget and make some decisions and choices and get some credit counseling. Now, when it comes to credit counseling, the banks and the lenders sometimes will give you some sort of a break. They may stop charging interest, or they may stop charging late fees and penalties. But the concept of a debt management plan is you submit to a credit counselor your disposable income over a period of time that it would take to address the debt, and they'll make payments out to your creditors, and creditors will usually back off when you're in a debt management plan. The problem with debt management plans is a lot of times they're unrealistically put together, and they're just doomed to failure from the beginning because they're not anticipating things that can come up in your life, more emergencies, medical hardships, reductions of income. So while a debt management plan is an option that you want to look into, you want to be careful not to hold all your hopes out there with a debt management plan being, the financial salvation without looking at other options. Now, also next along this continuum is what's called a debt settlement plan. And the difference for a debt settlement plan is while you'll make monthly payments into the debt settlement company, let's just use an example. Let's say you have $2,600 coming in a month and it costs you $2,200 to run your household. Well, then you have $400 a month disposable income. Those monies would be sent to the debt settlement company and they'll save up the money and then they'll make an offer out to a creditor. Now, first of all, these are for-profit entities, and that completely distinguishes them from a debt management plan, which more and more are for-profit entities, but some of them are still non-profit type of organizations. The debt settlement plan, there's nothing that they do that you can't do on your own, nor that our offices couldn't assist you in doing, but the debt settlement plans, to a large degree, they're too expensive. They almost always end in failure, and most of the groups that you work with are crooks, just to put it pure and simple. Along the continuum then is maybe you just need to raise a good defense. Maybe you just need to go in and respond to the lawsuit because you can defend it down. For goodness sake, if you're sued, don't just bury your head in the sand like a lot of people do. You need to go in and file a responsive pleading or an answer. And if you need to understand how to do that, schedule an appointment to meet with us in our office, and we'll talk to you about where you are, and we'll talk to you about the types of things that you need to do to protect yourself from these creditors receiving judgments that they might not be able to get if you just take the time to defend it. You might have a good statute of limitations defense, which basically is the creditor waited too long. Or you might have a good substantive defense. They don't have a good case or a claim at law, but not being lawyers, you wouldn't understand that. Also, in the non-bankruptcy alternatives along this continuum, there's just debt workouts. Sometimes you can work with your mortgage company to do a loan modification or a forbearance agreement or some sort of other workout with the creditor before you start looking at the bankruptcy alternatives. Bankruptcy alternatives, there's a Chapter 13, which is a repayment plan that usually runs anywhere from 36 to 60 months on a typical case. We're going to come back and talk more in depth about Chapter 13s in a few minutes. And then finally, on the other end, like I had explained, there's Chapter 7, liquidation bankruptcy. That's what most people think about when they hear the word bankruptcy. Okay, let's dig in. First of all, general concepts. Let's talk about the automatic stay. When a bankruptcy is filed, the fundamental cornerstone of a bankruptcy process or system is that the creditors are told, back off. The judge, under the authority of the federal bankruptcy or federal court system, issues an order that tells creditors to leave you alone. It's like an injunction, but it's a temporary order. It doesn't last forever. In a few minutes, we're going to talk about which debts can be forgiven completely or discharged is the word, and that's more of a permanent injunction. But the automatic stay operates as a temporary injunction, telling creditors, back off. Let these folks sort out their finances, let them get some idea of their relationships and their health and their job and everything. And let's take a look at what assets are out there that are protected. Let's appoint a trustee. Let's get a judge involved. When the bankruptcy petition is filed with the court, that triggers the automatic stay. And it is automatic with certain exceptions. If you've been in previous bankruptcies within the last year, the automatic stay may only last for 30 days. If you've been in more than one bankruptcy in the last year, the automatic stay may not even go into place at all, and you have to file a motion to impose the stay. Those are a little more technical things that we don't need to get into today in our overall concepts to begin with. Temporary relief from creditor collection activity means lawsuits have to stop, garnishment proceedings must stop, repossession threats, foreclosures, actual repossessions. There are some things that the automatic stay will not preclude. For example, the collection of child support or spousal maintenance continue. The collection of restitutional debts continue, or any other type of criminal liquidated damage. But those are very rare, and they're not very often does that come about. Okay, another general concept, let's talk about the bankruptcy estate. When a bankruptcy case is filed, there's a basket that's created. I like to use a visual approach when I'm speaking with my clients, because a bankruptcy estate is an artificial legal entity created by law. Kind of like a probate estate. When someone passes away, their property belongs to a probate estate. Kind of like a corporation, that when a corporation is filed, it's an artificial legal entity that's created by law. It can own property. It can sell property and buy property and sue people and be sued. Artificial entities can do these things just as well as a natural entity can do, like ourselves. Excuse me. So when a bankruptcy is filed, this bankruptcy estate is created and it's managed by a bankruptcy trustee. It's owned by the unsecured creditors. Let's just say that we filed for bankruptcy on the first day of next month. On that day, everything that we own becomes property of the bankruptcy estate. Now, that includes intangible assets as well as tangible. Sometimes people forget that there's things that we can't just put our hands on. My calculator, my hammer, my tools of my trade are tangible things. We understand those things go into the bankruptcy estate. But there's other things that are intangible, like a tax refund you may be receiving, or the right to collect something based on a lawsuit that you can raise. It's called a chosen action. There are intangible assets like bank accounts that become property of the bankruptcy estate. It also doesn't matter where these assets are located. They can be anywhere in the world. It doesn't matter by whom they are held. It can be being held by a friend or a family member or a trustee of some sort. It doesn't matter how they're held or where they're located. They become property of your bankruptcy estate. It doesn't matter how they were acquired. I'll have clients tell me, oh, well, that was a gift from my mom or dad, or that was it doesn't matter. If it's an asset you own at the day we file for bankruptcy, it becomes property of the bankruptcy estate. It also doesn't matter how important the asset is to you. It can still become property of the bankruptcy estate. I have clients who have things they cannot do without. And the importance doesn't matter, mean it's protected. Now, in a moment or two, we're going to talk about exemptions and protections of property. But generally speaking, the rule is any asset you own becomes property of the bankruptcy estate, regardless of these things that I've said. Assets that have been transferred away in the last 6 years for less than fair market value can be brought back into your bankruptcy estate. Monies that you've paid to creditors that were family members in the last year become property of your bankruptcy estate if they're what are called preferential transfers. It's a technical concept. Really, you need to speak with a bankruptcy attorney before you make any decision on how you're going to proceed relative to any payments that you made to family members. Any assets that you've conveyed away for less than fair market value can be deemed fraudulent conveyances and come back into your bankruptcy estate. And most importantly, things that you receive by inheritance or by property settlement in a domestic relations or a divorce proceeding, within 180 days or 6 months of filing the bankruptcy, come into your bankruptcy estate. You can see how this bankruptcy estate thing can get a little bit complicated. Bottom line is, everything you own on the day you file for bankruptcy or inherit or receive from a divorce settlement within 6 months of filing for bankruptcy becomes property of this bankruptcy estate managed by a Chapter 7 trustee. Let's talk about exemptions. Very simply, exemptions are property or assets that cannot be taken from you, either outside of bankruptcy or in bankruptcy. Exemptions are based on state law. They vary state by state. So if you know somebody who filed for bankruptcy in Missouri, they would be entitled to entirely different exemptions than what you'd be entitled to under Arizona's exemption law. Arizona's exemption law is very robust. It's very protective. It doesn't just protect you in bankruptcy. Now, we can get you a list of exemptable assets, or you can visit our office and we can show you what would be protected under Arizona law. Generally, you can protect up to $150,000 equity in your homestead. You can protect $6,000 equity in a motor vehicle that you own. You can protect up to $12,000 equity in a motor vehicle if you are physically disabled or if you're one of your children or a dependent of yours is physically disabled. You can protect up to $6,000 worth of your household goods. A wedding or engagement ring is protected up to $2,000. You can protect prepaid rent up to $2,000. You can protect bicycles and other assets of personal property that are specifically enumerated. Tools of your trade, tools that you use to earn an income for your family, are protected up to $5,000. And if you're married, you can exempt or protect up to $5,000 worth of the tools of the trade of your spouse. So that means a married couple could actually protect $10,000 worth of tools of trade. To some businesses, that's a lot. If you have a window washing business, $10,000 worth of tools of trade is way more than you would have. But if you're a mechanic and you use those tools to fix motors, engines, whatever, I have lots of clients who've been mechanics, and their tools are worth more than $5,000, and that's when the stacking of exemptions between spouses is very important. Exemptions are the part of the bankruptcy code that allow you to get a fresh start. If you lost everything, then you're really not getting a fresh start. You're starting from ground zero. But a fresh start in bankruptcy means that certain assets will be protected from the bankruptcy trustee. It means, with my basket example, that if everything goes into the basket, there are some assets, exempt assets, that come out of the basket, and you get to keep those. The trustee cannot manage those or sell those or use those to pay out to your creditors. Now, by definition, this basket, this bankruptcy estate, once the exempt property comes out, will still have assets in it that are called non-exempt assets, which means they're not protected. And that's what happens in a Chapter 7. In a liquidation bankruptcy, the trustee liquidates these non-exempt assets. In a Chapter 13, the non-exempt assets are still protected, and we'll talk about that in a few minutes when we discuss the anatomy of a Chapter 13 case. Bankruptcy exemptions like I mentioned, change from state to state. And there's also in the bankruptcy arena something you need to understand, that if you were in a state a couple of years ago, and then you want to file for bankruptcy here in Arizona now, we would have to use the exemptions from that state, because that precludes people from doing what's called forum shopping, or looking for a favorable venue that they could move to, live there for 90 days, and then go ahead and file for bankruptcy and be entitled to the higher exemption amount. Again, bankruptcy estates and exemptions are very complicated types of things. You need to discuss these with a professional who has experience. Let's talk about the types of creditors that are out there. There's basically two types of creditors as far as you're concerned. There's a secured creditor, which means you pledged collateral to that creditor, and then those who are not secured creditors are called unsecured creditors. Examples of secured creditors: your home mortgage, your liens, security that you pledged a lien in your car when you bought the car, or if you went to Sears or Best Buy and financed personal property. These are called consensual liens, and these consensual liens give the creditor a right to the property if you don't pay them. There are other types of liens out there. There is an involuntary lien. This usually comes up as a matter of statutory law. Well, what do I mean by that? The federal government has a rule in its statutes, Title 26 of the United States Code, that says if you don't pay your taxes when you owe them, the federal government can put a lien in your county recorder's office that indicates that they have an involuntary lien against everything that you own. And you're not going to be able to sell your property or transfer your property without taking care of that lien. There's a third type of lien that creates a secured transaction, or creates a security interest for the creditor, which makes them a secured creditor. And that's a judgment lien. If somebody sues you and gets a judgment, they can record that judgment with the county recorder's office, and that means you're not going to be able to sell your home without satisfying that lien. That means you're not going to be able to transfer assets without addressing those liens if there's any type of a recordation of that lien. It's very important, again, if you're sued, not to allow that lawsuit to go to a judgment by default, because the next step is there may be a judgment lien filed against you. Well, most of the liens we deal with, most of the secured creditors we deal with, are consensual liens. You pledged your home, you pledged your car, you pledged the personal property you bought. And when you file a bankruptcy, secured creditors are better. They're treated differently than unsecured creditors. You either have to give them that collateral back, give them the home, give them the cars, give them the personal property, that's electronics, appliances, furniture, or you have to agree to keep paying them for it. And that's called reaffirmation. If you reaffirm on the debt, it simply means you put yourself back on the hook for the debt, and you bring back into being the promissory note that you signed, because the purpose of bankruptcy is to get rid of promissory obligations. And by so doing, you're allowed to keep that asset in a Chapter 7 bankruptcy if the creditor agrees. Now, if you've been late on your payments, if you've really not kept that property protected, if you haven't kept your insurance in place, they might not do a reaffirmation agreement with you. They may just say, enough, we're worried about that collateral. That $10,000 car out there is in jeopardy because of what's going on. We're not going to reaffirm with you. We just want the asset back. Reaffirmations can also be very dangerous if you sign yourself back up on a debt that's a lot more than what the collateral is worth. For example, if you have a car that's worth $10,000 and you owe $18,000 on it, we don't want to sign a reaffirmation, because if you, for some reason your job situation changes or your health situation changes and you have a reduction in income and you can't afford to pay this $18,000, they're going to repossess the car. They're going to sell it for maybe $7,000, $8,000, apply the proceeds to your balance on your promissory note, and the resulting amount is called a deficiency. And deficiencies, they can still continue to collect even though you don't have the car at all. And if you've already filed for bankruptcy, you're not eligible for bankruptcy again. They'll be able to garnish your wages for a long time. Reaffirmations are very dangerous. Be very careful before you sign one, and make certain that you get qualified, competent legal advice before you do so. Okay, let's talk about unsecured creditors for a moment or two. Unsecured creditors are creditors that you didn't pledge collateral to. Medical bills, utility bills, most credit cards. Now, some credit cards could be secured, but these types of creditors generally and usually are dischargeable in bankruptcy unless you've done something improper, unless you've incurred this debt by false representations. You didn't intend to pay the debt or didn't have the money to pay it when you told them that you could. This doesn't come up very often, but it is something that we'll discuss briefly in a moment or two as we determine and discuss the dischargeability of debt. Okay. Can we get rid of a debt or not in bankruptcy? Is it forgivable? Can it be erased? The word in the legal arena is called, is it dischargeable? Can you discharge the debt? We can discharge debt as a matter of public policy. It's part of our United States Constitution that says we have the right to ask the federal court to stand between us and our creditors if we file a petition for relief. A discharge is a permanent injunction against collection activities. And that's as opposed to the temporary injunction that I was talking about earlier when we were talking about the automatic stay. You cannot discharge or receive forgiveness from child support, from spousal maintenance, from debts for fraud, embezzlement, willful injury, malicious injuries, DUI obligations, criminal restitution debts, most taxes, most student loans. Debts that you fail to list on your bankruptcy aren't dischargeable. Credit card companies, like I mentioned previously, can file a lawsuit against you within the bankruptcy to argue against the dischargeability of your debt. They would ask the court to consider all the circumstances and determine whether or not you are eligible for a discharge. These don't come up very often, but if there's a potential for them to come up, again, it's important for you to have discussed your personal financial situation with a qualified and competent consumer bankruptcy attorney before you file your case with the court. Sometimes, by the time you file your case with the court, the bell has been rung and you can't unring a bell. I have a colleague who's indicated that filing a bankruptcy in Chapter 7 is like going through a car wash. Once the washers start going, it's too late to roll up your windows or take your antenna down or pull your foot off the brake or put your car in neutral. There's damage that's going to happen if you hadn't prepared yourself. The most important part of filing for bankruptcy is preparation of your case. Now, when it comes to dischargeability of these debts, they're treated differently in the different types of bankruptcy. So let's talk first of all along our continuum of debt relief alternatives. Let's talk about a Chapter 13 bankruptcy. A Chapter 13 is a repayment plan based on a family's or an individual's ability to pay, based on what's left over after you take care of your most basic living expenses. First question is, am I eligible for a Chapter 13? Well, you're not eligible for a discharge in a Chapter 13 case if you file that Chapter 13 and it's been less than 4 years from the time that you filed a Chapter 7 bankruptcy that resulted in a discharge. You're not eligible for a Chapter 13 if you have more than $380,000 unsecured debt or somewhere around $1,100,000 secured debt. You're also not eligible for a Chapter 13 bankruptcy based on actions that you might have taken in previous cases. If a judge ordered you to do something and you failed to do it, or if you willfully decided not to do it, there might be a 180-day or 6-month preclusion from your eligibility to file a Chapter 13 bankruptcy case. Will that keep you from walking up to the clerk of the court's office and submitting a bankruptcy? No, you can still do that. That'll put a bankruptcy in your credit report. But it will preclude you from getting the relief that you want out of bankruptcy. We don't file bankruptcy just to file a case. We file it to get some sort of relief, some sort of breathing room, or whether it's temporary or permanent. Now, when we file a Chapter 13, secured creditors are treated a little differently than a Chapter 7. In a Chapter 7, I mentioned you either have to surrender the asset or reaffirm on it. In a Chapter 13, we can pay it through the plan, so we get to keep property. We get to keep assets that otherwise would have been taken in a Chapter 7 through liquidation. Remember the non-exempt assets that I talked about in the basket? These things could be taken and sold by a Chapter 7 trustee, but a Chapter 13 trustee has to allow you 36 to 60 months to pay for those things so you don't lose them. That could be equity in a motor vehicle that you would lose, something you need to drive back and forth to work, or to take your kids to the doctor's and dentist appointment, or to school, or to go to the grocery store. If there's a jeopardy on your vehicle, a Chapter 13 can help us protect that. If there's a jeopardy on your home, if it's subject to foreclosure, then we can stop the foreclosure process by filing a Chapter 13, committing to catch up what we were behind if we can afford that, and agreeing that we're going to keep the regular payments current as they come due month to month. With a Chapter 13, there are 5 tests. There's what's called the median income test, which determines whether or not you're eligible for a 3-year plan or have to do a 5-year plan. There's a means test that determines whether you're even eligible for a Chapter 7, or if you do a Chapter 13, how much do you have to pay back to unsecured creditors? There's a disposable income test, which asks very simply, what do you have coming home? And what does it cost to run your household? In my previous example, we have $2,600 a month coming home, net take-home pay. And we have $2,200 a month reasonable living expenses. That leaves us with $400 a month disposable income. There's also what's called a best interest of the creditors test. If we file a Chapter 13, we have to pay to unsecured creditors at least what they would have received had there been a Chapter 7 liquidation bankruptcy. If I have a $4,000 quad and filed a Chapter 7, I can't exempt it, so it's non-exempt. If it's free and clear, it has $4,000 worth of equity, the trustee could take it and sell it and use those monies to pay out to my creditors. Now, if I don't want to lose the quad because I use it for hunting, or I use it on the farm, or I use it for recreation, if I file a Chapter 13 bankruptcy, I can protect the quad, but your unsecured creditors would have to receive at least that $4,000. It's a fairness or a good faith concept. Chapter 13 bankruptcy, the anatomy is like this. We prepare the case, we file the petition, the schedules, the statement of financial affairs, we file a plan, and then we work to get that plan confirmed by the court. That means to get all the creditors to agree to it. We deal with the creditors' objections to the plan. We deal with the trustees' concerns and objections to the plan. We also resolve any conflicts in terms of proofs of claim that have been submitted. And when we can get all of that arranged, that'll take us 8, 10, 12 months sometimes, then the judge will sign an order confirming. Now, in a Chapter 13, you're making a monthly plan payment of that. In this case, we've been mentioning $400 a month disposable income goes into the Chapter 13 plan, and the judge tells the trustee where to disperse that money and who to pay it to. We treat secured creditors first and mortgage arrears. We treat priority taxes. We treat unsecured creditors or non-priority debts last. With the Chapter 13 plan, you need to understand that some administrative expenses happen. The trustee gets a percentage of everything goes through the plan. Your attorney's fees can be addressed in the plan. Some other court costs are addressed in the plan. Chapter 13, once we get it agreed to signed off by the judge in the confirmation order, then really it's your job just to keep the plan payments paid every month. You have to make plan payments from the day we file your case until it gets confirmed, and then throughout however long the judge says the plan needs to run. There's advantages of a Chapter 13 over a Chapter 7. We can protect property. We can cure mortgage arrears. Sometimes people just want to pay what they can afford to pay back, and that's an advantage that Chapter 13 allows us. Okay, let's look at Chapter 7 in a little more detail like I mentioned earlier in the seminar. Chapter 7, we have to look at eligibility again. If you filed a Chapter 7, within the last 8 years that resulted in a discharge, you're not eligible to file a Chapter 7 now that will result in a discharge. And it does no good to file a bankruptcy that doesn't result in a discharge and permanently tell your creditors to back off. There's also the median income test, like I talked about during the Chapter 13 process, which compares your household with the number that are in your household to your income based on the U.S. Census Bureau statistics of what a median household in your state has. So let me deal less theoretically, and let's just talk. If the U.S. Census Bureau statistics says that a household of two would have a $48,000 gross income as a median income, if your household income is $55,000 or anything over, the $48,000, then you have failed what's called the median income test, and you're not eligible for a Chapter 7 bankruptcy unless you pass the means test. The means test says we take into account your gross income over the last 6 months. We divide it by 6, so it gives us an average monthly income. We subtract from that what the government will allow you to expend on your household for keeping your household afloat, insurance and food and transportation and housing and this type of stuff. And then your secured creditors, the debt, the monthly payment on those is deducted off. And the result is, what would you have left over to pay to unsecured creditors? If it's a negative number, you pass the means test. If it's a very nominal number, you might still pass the means test. But if it allows you to pay 1/4 of your unsecured creditors back, you're not eligible for a Chapter 7 bankruptcy. We'd need to look at a Chapter 13 bankruptcy. When it comes to secured creditors in a Chapter 7 bankruptcy, we still, like we discussed before, we have to address their lien. When we incurred the debt, we signed a promissory note, but we also made pledged a security interest or some sort of a non-possessory interest in that property, the house, the car, the personal property. When we filed Chapter 7, we're on our way to discharging that promissory obligation, but we still have to deal with the lien. How do we deal with the lien? We either surrender the collateral back to the creditor, or we pay them the fair market value of the collateral, that's called redemption, or we reaffirm the debt, we bring this promissory note back again. Sometimes we can bring it back with a different terms, a lower payment or a more favorable interest rate. Not always. Some creditors just say, no, we're not going to negotiate. If you want a reaffirmation, reaffirm on the same terms. Like I discussed before, we don't get to control the reaffirmation process. It requires that we negotiate with the creditors. Usually it takes about 6 months to complete a Chapter 7 bankruptcy. A Chapter 7 is the liquidation form of bankruptcy that most people think about when they hear the word bankruptcy. Let's talk about the anatomy or the timeline of a Chapter 7. It usually takes about 6 months. It begins with us preparing the case and looking at the proper timing to file. Then we get all the schedules and the statements and the petition prepared, and we file them with the court. The automatic stay goes into place. About 5 or 6 weeks later, you would need to attend what's called the meeting of creditors. I beg your forgiveness. When I discussed Chapter 13, I didn't mention the meeting of creditors, but there's a meeting of creditors for the Chapter 13 as well. And that's a time for the creditors to come and ask you questions. You would have to show up at a hearing at the courthouse. The trustee will be there. Someone from our office will be present with you. And the trustee is usually the only one who shows up. Creditors rarely show up. So don't lose any sleep over the hearing. It's very straightforward. But they are going to want you to testify that everything you put down in your paperwork was true and correct. They want you to testify under oath that whatever you answer during that hearing is going to be true and correct. So all you have to remember about the 341 hearing is get a good night's sleep and then come into the hearing and tell the truth. It's a very straightforward process. They're going to ask your name. They're going to ask you if you assisted our office in the preparation of your bankruptcy paperwork. Did you have a chance to review the information before you signed it? Was it true and correct? Are there any adjustments or corrections that need to be made at this point? After the meeting of creditors, the creditors have 60 days to file a complaint for non-dischargeability if they think they can prove that the debt that you owe to them should survive the bankruptcy. Now, this isn't child support or spousal maintenance or these types of things. It's the type of debt that I mentioned, the willful or malicious injury. This isn't the government isn't going to have to come in and prove that you owed them a fine or a DUI obligation. Those survive bankruptcy without this lawsuit. This is where some creditor is going to need to show that you've done something improper. The credit card companies is about the only ones that I've seen generally that raise complaints for non-dischargeability with limited exceptions. Now, After the bar date has run for filing a complaint for non-dischargeability, usually about 30 to 40 days later, the clerk of the court is going to issue a discharge in your Chapter 7 bankruptcy. It's very important that you remember that when we file a bankruptcy, we start a legal case or a legal proceeding that results in a discharge or not. But there's also a bankruptcy estate that's created in Chapter 7 that can extend beyond the time of the 6 months of your Chapter 7 bankruptcy. Remember, the trustee is charged with the responsibility of gathering the assets in, turning them into cash by selling them, using the cash to pay out pro rata. In other words, based on the amount of a claim, if one creditor is owed more than another, they'll receive a higher distribution as an unsecured creditor from whatever available resources is out there. What types of things are normally taken by Chapter 7 trustees? Well, toys like the example I used earlier with regard to the quad. They take tax refunds. They take personal injury claims. If you were in an auto accident or a slip and fall at a business and you have a claim that you can sue somebody, the trustees can take on behalf of the bankruptcy estate and step into your shoes and prosecute that claim for personal injury or collect that tax refund directly from the tax agency. Chapter 7 liquidation bankruptcy, you need to understand, is the most common form of bankruptcy, but it's not the only type of bankruptcy. And there are attorneys out there who will only discuss with you Chapter 7, or they may discuss Chapter 13, but they'll recommend Chapter 7 because that's all they do and are comfortable with. Chapter 13s are more complicated and require more time. And to be quite honest with you, are not nearly as financially rewarding as something that's over in 6 months and you get on with your life. Okay, just one last warning. Be very careful in this interim time between now and when you go and speak with a qualified, experienced professional in the consumer bankruptcy arena. Don't transfer any assets because it could give rise to an avoidance action by the trustee that brings that asset back into the bankruptcy estate. Well, the damage is you're not able to make some plans. We can't do some pre-bankruptcy exemption planning if you don't have those assets. So I've had clients that have transferred assets away to protect them. They've transferred a car away to their brother that they could have exempted, but transferred to their brother, they're non-exempt, and they guarantee they'll lose that asset. When we need to solve a problem in our life, we go to try to get information and advice, and it's very difficult to understand which advice is correct. You want to be very careful not to get advice on bankruptcy matters from someone who's filed for bankruptcy before, a friend, a family, a coworker, or even if they didn't file a bankruptcy before, if they know something about bankruptcy because they've been involved as a creditor or because they have a friend or a coworker. Colossally bad advice comes from people who don't practice regularly in the consumer bankruptcy arena. There are document preparers out there that sometimes people will go and get bad advice from, and the reason the bad advice comes from them is because they're not down at court all the time understanding that judges are changing bankruptcy law on a daily, weekly, monthly basis. There's all kinds of changes that attorneys are keeping abreast of and spend time in their day talking to other colleagues about what's changing, and we share with each other what types of things we need to worry about today that we didn't have to worry about a month ago. It's critical. Part of the be careful, it's critical that if you do file for bankruptcy that you list all of your assets. You don't want a trustee coming back and arguing that your Chapter 7, Chapter 13 bankruptcy should be dismissed for bad faith, or the bankruptcy discharge be revoked because you tried to hide an asset, when merely what you did is you just overlooked it. Don't overlook assets. This is a day and age where you need to comb through your finances and make very careful calculations and assessments of your income and expenses and your assets and liabilities. Be sure to list all the debts that you owe. If you don't list all your debts, they won't be discharged. Now, you also don't have the luxury of deciding who you're not going to list in your bankruptcy. You can't leave mom off or aunt whoever off or uncle whomever off just because you don't want them to be part of the bankruptcy. Nothing in bankruptcy law will preclude you from paying those creditors in the future, but you do have to schedule and list all your debts. Timing. Don't wait to get advice. Don't wait for the moons to line up. Make an appointment tomorrow to go meet with a qualified consumer bankruptcy attorney who is experienced. That's when the process and the planning and the strategic approach can begin. And the longer you wait, the more mistakes you might make, unwittingly. In closing, first of all, this is just a brief summary of all the complexity of consumer bankruptcy law. You don't have to know everything. You just need to know enough information to make the decision of whether to file, and if you're going to file, what type of bankruptcy to file. If you're not going to file, what type of non-bankruptcy alternatives are available to you? And a consumer bankruptcy attorney is a great resource to find that out. Every single case is different. Your case is unique. There's common things that I see all the time, but as we develop an amalgamation of all the elements of who you are and your health situation, your relationship situation, where you've been in life, what your career is, what your income and earning capacity is, all of these things make you as unique as a snowflake and your personal financial situation just as unique. Don't make any decisions or changes until you've had a chance to meet with someone who can recognize that uniqueness and pigeonhole and answer your questions relative to your personal financial situation. Finally, trust me, you need a personal debt planning appointment. If you're struggling with your finances and don't know which along this continuum of alternative options applies to you, schedule an appointment. Be prepared to come in and explain all your income, all sources of it, all your expenses on a monthly basis, all of your assets, all of your liabilities, what they're worth in terms of the assets and what you owe in terms of liabilities. And then your trained consumer bankruptcy attorney with experience can explain to you what they would do if they woke up in your shoes. That's the way I treat every case that comes in. I advise my clients based on information that I gather, based on what I know, of how I would approach this particular financial situation if I woke up in your shoes. Hey, thanks for participating. Thanks for watching to the end. I hope that this has been helpful for you. I really would like to be a resource for you in getting you past this stage in your life and moving on to a more secure, sound, and safe financial future. Thanks for taking your time. I'll look forward to meeting with you in my office when you get a chance to schedule an appointment.